In Washington, former President Donald Trump is due to go on trial on March 4th over his efforts to overturn the 2020 election. Now, that is barely 6 months away, if you can believe that, and one day before a key moment in the 2024 election, where Donald Trump, as you know, is the leading Republican candidate. Scott MacFarlane was there yesterday when the judge set that trial date.
The federal case against Donald Trump for allegedly trying to overturn the 2020 election and his current campaign are now poised to collide head-on in March. Over the protest of defense lawyers, Judge Tanya Chutkan set jury selection to begin on the first Monday in March, just one day before Super Tuesday.
He's running for office, but she said at the same time that doesn't mean that everything gets pushed back until after the election.
A Trump defense lawyer argued so loudly they needed until 2026 to review the millions of pages of evidence, the judge twice asked him to take the temperature down. But prosecutors argued by waiting, Trump could taint the jury pool with his ongoing vitriolic public statements.
I have a guy, they call him Deranged Jack Smith. He's deranged.
Hello and welcome everyone. Dr. John is here. Every defendant wants more time, and the legal system has mechanisms for that. But the principle underneath all of them has held for centuries. The defendant doesn't choose when the trial happens. The court sets the date. You show up. That's the bargain. That's always been the system. Donald Trump's legal team has spent the past several years trying to carve out an exception to that principle, arguing through every available channel that their clients' unique circumstances justify a fundamentally different approach to trial scheduling. His status as a presidential candidate, the demands of a national campaign, the unprecedented nature of prosecuting a former president who is seeking to return to office, all of these factors have been deployed repeatedly as grounds for pushing trial dates further and further into the future. The goal has never been particularly subtle.
And we are taking a live look right now at New York City, courtesy of EarthCam. And right now we are waiting to learn a judge's decision after former President Trump asked for his sentencing to be delayed. Trump was convicted back in May on 34 felony counts of falsifying business records to hide a 2016 deal to pay off adult film star Stormy Daniels. But after the Supreme Court ruled that the presidents have immunity for official acts, Trump's legal team requested a delay to build a case for the verdict to be overturned. Now the former president's team is asking the judge to delay his sentencing until after the November election.
If the trials happen after the election can change the circumstances in ways that make the trials disappear. The delay is not merely a litigation tactic, it is the entire strategy. That strategy ran headlong into a federal judge who decided that the standard rules were going to apply in her courtroom, regardless of who the defendant happened to be. Judge Tanya Chutkan looked at the stack of motions and the competing proposed schedules and the arguments about campaign rallies and primary debates, and she did what judges in criminal cases are supposed to do. She set a date, not the date the prosecution wanted, which was aggressive and early, not the date the defense wanted, which was so far in the future that it would have guaranteed no trial before voters went to the polls.
Former President Trump's election interference case won't be held before the election. Legal affairs correspondent Abijoy Burnett joins us now. Abijoy, you were in the courtroom today. We know that the judge has entered a new order here. What exactly does this order say?
So this is breaking news that's coming in. It is a scheduling order to determine how this case would move forward. And the big question that we had was, would we possibly see a trial before Election Day? Even though legal experts said that was not going to happen, we now officially have the answer from Judge Tanya Chutkan. She issued the scheduling order. There is no mention of a trial date. However, there are some filing deadlines that are 2 days after Election Day. So if you put it all together, that pretty much means we will not see a trial in this January 6th case before election day.
A date that split the difference and came with language that left no ambiguity about where the court stood on the question of whether a presidential campaign schedule overrides a criminal docket. The date was March 4th. The year was 2024, the day before Super Tuesday, the most consequential single date on the primary calendar, the day when the largest number of states hold their presidential primaries, and the day when the Republican nomination was expected to be effectively decided. And the judge's explanation for why she chose that date and rejected the defense request for a delay stretching into 2026 was as clear as any judicial statement in any courtroom in America. Setting a trial date does not depend and should not depend on a defendant's personal personal obligations.
And as I just mentioned, we have a date. A federal judge has set March 4th, 2024 as the trial date in former President Trump's election interference case. U.S. District Judge Tanya Chutkan made that decision. Trump's team had asked for an April 2026 trial, while special counsel Jack Smith's team had asked for a January 2nd, 2024 trial. CBS News Chief Washington correspondent Major Garrett joins us now. Major, it sounds to me like the judge, of course, sided more with what Jack Smith's team wanted than with the Trump team. What do you make of that date?
So the first thing we need to understand is this may not be the absolute date set in stone, March 4th, but it will be somewhere close to that. Trump's legal team will have the opportunity to offer motions and may slow things down, but it's going to be March or April of next year. And that is much, much closer to the prosecution's wishes than the Trump defense team suggested. April 2026 was something that the judge said was simply unreasonable.
Those words, spoken in open court with the defendant's attorneys standing before her, represent one of the most direct and legally significant rejections of the Trump delay strategy that any judge has delivered. They are not complicated. They are not hedged with qualifiers or exceptions. They state a principle that applies to every criminal defendant, from the least powerful to the most powerful, and they apply it to Donald Trump without modification or accommodation. The scheduling fight that produced this moment had been brewing for weeks. Special counsel Jack Smith's team had asked for a January 2024 trial date in the federal election interference case, the case charging Trump with conspiring to overturn the results of the 2020 election. The prosecution argued that the evidence was ready, that the case could be tried efficiently, and that the public interest in a resolution before the 2024 presidential election was compelling. January was aggressive but defensible given the complexity of the charges and the preparation the government had already completed. Trump's legal team responded by asking for a trial date of April 2026, not April 2024, not even April 2025, April 2026. A date more than 2.5 years into the future, long after the election would have come and gone, long after the political circumstances that made the trial such a threat to Trump's electoral prospects would have been resolved one way or the other. The request was so extreme that it was almost audacious, a demand that the court effectively grant immunity through calendar manipulation rather than through legal argument. Judge Chutkan split the difference. She gave the prosecution a date later than they wanted and the defense a date radically earlier than they wanted, March 4th, 2024, the eve of Super Tuesday, a date that would place the leading Republican presidential candidate in a federal courtroom answering charges related to the attack on the Capitol on one of the most politically significant days of the entire primary season. The symbolism was unavoidable, and the political implications were immediate. Trump's response was exactly what anyone who has followed his legal battles would have predicted. He exploded on social media. He called it election interference. He claimed the date was specifically chosen to damage his campaign and prevent him from competing effectively in the Super Tuesday primaries. He vowed to appeal, to fight, to use every available mechanism to prevent the trial from proceeding on the schedule the judge had established. The language was familiar. The framing was familiar. The outrage was part of a pattern that has repeated itself across every adverse judicial ruling in every case he faces. The social media explosion served its political purpose. It generated headlines and activated supporters and reinforced the narrative that the legal system was being weaponized against him for political ends. But in the courtroom, where the actual legal proceedings take place, the explosion had no effect on the schedule. The date was set. The order was entered. The judge had spoken. Legal analysts who examined Chutkan's scheduling decision were quick to note a procedural reality that Trump's social media followers may not have fully understood. Simple order-setting trial dates are not directly appealable. You cannot take a scheduling decision to an appellate court and ask the higher court to second-guess the district judge's calendar management. The trial date is a matter of docket control, and district judges have broad discretion over their dockets. Trump could fume about the date on Truth Social. He could call it election interference at his rallies. He could tell his supporters that the judge was corrupt and the system was rigged. None of that changed the legal reality that the trial was now scheduled and the defendant was expected to prepare. The delay strategy, however, did not end with Chutkan's rejection of the direct request for postponement. The legal team had other procedural mechanisms available, other avenues for buying time, and the most significant of those mechanisms turned out to be the claim of presidential immunity. Trump's lawyers argued that he was absolutely immune from criminal prosecution for any official acts undertaken while he was president. And they raised that argument as a constitutional question that had to be resolved before any trial could proceed. When the Supreme Court agreed to hear the immunity question, the entire proceeding ground to a halt, while the justices considered whether a former president could be prosecuted for conduct related to his official duties. The immunity appeal achieved what the direct delay request could not. It stopped the trial clock. The March 4th date came and went without a jury being seated, without opening statements, without a single witness taking the stand. The Supreme Court took its time with the immunity question, as the Supreme Court does with questions of such constitutional magnitude. And while the court deliberated, the political calendar continued to advance. The 2024 election happened. Trump won. And when the new administration took office, the Justice Department dismissed the federal charges. The trial that Chutkan had scheduled for March 4th never took place. The outcome of the federal election interference case illustrates something essential about the relationship between judicial authority and political reality. Chutkan did everything a judge is supposed to do. She set a reasonable date. She rejected specious arguments for indefinite delay. She applied the law as it applies to every other criminal defendant. She was correct on the law and firm in her management of the docket. And it did not matter in the end because the delay strategy found a different mechanism, the immunity appeal, that bought enough time for the election to change the circumstances and end the case entirely. That does not mean Chutkan was wrong. It means the system contains vulnerabilities that a well-resourced and creatively lawyered defendant can exploit. The direct road to delay was blocked, so the legal team found an indirect road, a constitutional question that the Supreme Court had to resolve. And that indirect road led to the same destination the direct road would have reached. The trial was delayed past the election, and the election made the trial go away. The parallel proceeding in New York provides the contrast that makes the federal outcome so revealing. In the Manhattan hush money case, Judge Juan Merchan took a similar approach to Chutkan's. He set a trial date, March 25, 2024, and he rejected the defense motions to dismiss. Like Chutkan, he signaled through his scheduling decisions that he intended to move the case forward on a normal criminal timeline regardless of the defendant's status and regardless of the delay arguments being advanced. The case was not halted by an immunity appeal because it involved conduct that predated the presidency and did not implicate the same constitutional questions. The trial proceeded. The jury was seated. The evidence was presented. The verdict came back guilty on all 34 counts. The difference between the two outcomes, dismissal in the federal case and conviction in the New York case, is not primarily about the skill of the lawyers or the quality of the judicial management. It is about jurisdiction. Federal charges can be dismissed by a politically controlled attorney general. State charges cannot. When the election changed the political control of the Justice Department, the federal charges disappeared. The New York charges, filed by a state prosecutor in a state court system, were beyond the reach of the new administration. The conviction stood. The sentence was imposed. The defendant became a convicted felon 10 days before his second inauguration. That jurisdictional distinction is the most important structural feature of the entire Trump legal accountability landscape. The federal system, for all its resources and sophistication, contains a political vulnerability at the top. The Attorney General serves at the pleasure of the president and can be replaced when the presidency changes hands. State prosecutors, particularly elected district attorneys, operate on a different track. They do not answer to the federal executive. Their cases cannot be dismissed by a new attorney general. The New York conviction survived the election because the election did not change who controlled the Manhattan District Attorney's office. The procedural mechanics of trial date setting deserve careful attention because they reveal the institutional logic that Chutkan was applying and that Trump's team was trying to circumvent. In a normal criminal case, the trial date is determined by the complexity of the charges, the availability of counsel, the needs of the court's docket, and the statutory speedy trial requirements that establish minimum timelines for bringing a defendant to trial after indictment. The defendant's personal schedule, their professional commitments, their family obligations, their travel plans are generally not significant factors in this calculus. Defendants are expected to make themselves available for their own criminal trials. That is the fundamental nature of being a criminal defendant. Trump's legal team argued that his situation was different and justified a different approach. He was running for president, he had campaign events and primary debates and rallies that required his presence. The demands on his time were extraordinary, and the stakes of the election were enormous. Furthermore, the legal team itself was stretched across multiple proceedings in multiple jurisdictions, making it difficult to prepare adequately for an early trial date. These arguments were not entirely without merit in the abstract. Courts do sometimes take account of genuinely extraordinary circumstances in making scheduling decisions, but Chutkan evaluated those arguments and found them insufficient to justify the multi-year delay the defense was requesting. Her holding that personal obligations do not govern the court's trial date reflects a principle that is foundational to criminal procedure. If the defendant's personal schedule could override the court's docket, then every defendant with significant professional or personal commitments would have grounds to delay their trial indefinitely. The principle exists precisely to prevent powerful defendants from using their power to avoid accountability. The specific choice of March 4th, the day before Super Tuesday, added a political dimension to the scheduling decision that Trump immediately seized upon. His argument was straightforward. The judge deliberately chose a date that would inflict maximum political damage by putting him in a courtroom on the eve of the most important primary day of the campaign. The timing was not coincidental. It was targeted. It was election interference conducted from the bench. Chutkan rejected that characterization. Her position, consistent with standard judicial practice, was that she was managing a criminal docket based on the readiness of the case and the needs of the court, and that the political calendar of the defendant's presidential campaign was not the organizing principle of her scheduling decisions. The fact that the date she chose happened to fall near an important primary was a consequence of the calendar, not a motivation for the choice. If courts were required to schedule criminal trials around the electoral calendar of defendant candidates, the practical result would be that running for office would function as a shield against criminal prosecution. That is precisely the outcome the law is designed to prevent. The social media explosion that followed the scheduling order is best understood as a political communication rather than a legal argument. When Trump calls a trial date election interference, he is not attempting to persuade the judge. Chutkan is not going to read his Truth Social posts and reconsider her scheduling decision. He is communicating with his supporters, with potential jurors in the court of public opinion, and with the broader political environment that will determine the electoral consequences of the legal proceedings. The election interference framing is designed to make every legal development, every scheduling order, every adverse ruling, every eventual guilty verdict into evidence of the political conspiracy that his base is primed to believe is happening. This is the dual-track strategy that has allowed Trump to manage the political consequences of his legal jeopardy even as the legal proceedings have produced results that contradict his claims of total innocence. On the legal track, his lawyers make arguments to judges based on procedural rules and constitutional principles. On the political track, he makes arguments to supporters based on persecution and conspiracy. The two tracks serve different purposes and operate by different rules, but they reinforce each other. Every legal setback becomes political fuel. Every procedural delay becomes proof that the system is rigged against him. The ultimate fate of the Chutkan trial date illustrates both the power and the limits of judicial authority over a sophisticated and well-resourced delay strategy. Chutkan did everything correctly from a legal standpoint. She set a reasonable date. She rejected the argument that the defendant's campaign schedule justified indefinite postponement. She applied the standard principles of criminal procedure. The date was locked and the trial was moving forward. But the delay strategy did not need to win on the specific question of trial scheduling. It just needed to find another procedural mechanism that would halt the case long enough for the political circumstances to change. The immunity appeal was that mechanism. When the Supreme Court agreed to hear the immunity question, the case entered a holding pattern. The constitutional issue had to be resolved before the trial could proceed, and constitutional issues take time. The court does not rush questions of such magnitude. The months passed. The immunity arguments were briefed and argued and deliberated. The March 4th date slipped away. The election approached and then arrived and then concluded. And by the time the constitutional dust settled, the political landscape had been transformed. The defendant who had been facing trial was now the president-elect, and the Justice Department that had been prosecuting him was about to come under new management. The dismissal of the federal charges was the final act of a drama that Chutkan's scheduling order had tried to prevent. She She had set a date specifically to ensure that the trial happened before the election could change the circumstances. The delay strategy had found a way around her order. The outcome was not what she intended, but it was the outcome that the system's procedural vulnerabilities made possible. The New York case tells the other half of the story. Merchant set a date in roughly the same time frame. The defense deployed every available procedural mechanism to delay. Some of those mechanisms succeeded in slowing the process, but the immunity claim that halted the federal case did not apply in New York because the conduct at issue, falsifying business records to conceal hush money payments, predated the presidency. There was no constitutional question to appeal to the Supreme Court. The case stayed on track. The trial happened. The jury convicted. The system worked the way it is supposed to work, and the jurisdictional difference between state and federal charges proved decisive. The broader significance of the Chutkan scheduling order extends beyond the specific case in which it was issued. The principle she articulated, that trial dates do not depend on a defendant's personal obligations, is a principle that applies to every criminal defendant in every federal courtroom. By stating it clearly and applying it directly to the most politically significant defendant in the country, she reinforced a norm that is essential to the functioning of the criminal justice system. Powerful people do not get special scheduling accommodations. Running for president does not exempt you from the obligations of a criminal defendant. The court's calendar governs. That principle will outlast the specific case. Future judges will cite it. Future defendants with significant personal commitments will be reminded of it. The Chutkan order has become part of the permanent legal landscape, a reference point for the proposition that the criminal justice system does not bend its procedures to accommodate the political ambitions of the people who pass through it. The immunity ruling that ultimately halted the Chutkan case raises questions that extend far beyond Trump. The Supreme Court's decision on the scope of presidential immunity from criminal prosecution will shape the legal landscape for every future president and every future prosecution of executive branch conduct. The specific contours of that ruling, what acts are immune and what acts are not, what procedures must be followed before immunity can be overcome, will determine whether the presidency has become effectively unaccountable to the criminal law for conduct undertaken while in office. Those questions are not yet fully resolved. The court's ruling answered some of them and left others open. Future cases will test the boundaries. Future administrations will have to navigate the precedents. The long-term consequences of the immunity decision are still unfolding, and they will continue unfolding for years or decades to come. What the Chutkan episode ultimately demonstrates is that the relationship between judicial authority and political reality is more complex than the simple question of whether a judge sets a trial date. A judge can do everything right, can apply the law correctly, can manage the docket firmly, can reject specious arguments for delay, and still find that the system's procedural pathways provide enough detours for a determined defendant to reach a different destination. The delay strategy did not defeat Chutkan on the law. It went around her on the procedure, and the election provided the exit that the courtroom had not. The lesson is not that firm judicial management is futile. The New York case proves otherwise. The lesson is that the system contains vulnerabilities that can be exploited by defendants with sufficient resources and sufficient willingness to use every available mechanism, and that those vulnerabilities are more consequential in the federal system, where the ultimate prosecutorial authority is politically controlled, than in state systems where it is not. The Chutkan scheduling order remains one of the most important judicial statements in the entire Trump legal saga, not because it achieved its intended result, but because it stated with unmistakable clarity the principle that the delay strategy is designed to undermine. Defendants do not get to schedule their own trials. Campaign obligations do not override criminal dockets. The court sets the date and the defendant shows up. That is how the system works when it is working properly. Whether it is working properly in any given case depends on factors that even the firmest and most principled judge cannot always control.